There's been the topic of conflict of interest has come up in many meetings, in board meetings, in work sessions, in meetings with advisory committees and other circles. There's been the comment of conflict of interest, and we've never really thoroughly discussed it. It's been mentioned, a little bit of discussion, and then it was kind of brushed off. Recently, other communities have had issues with conflicts of interest. Specifically, I think it was Arvada. Is that correct, Sandy? Is Arvada? Or Aurora?
Boulder.
Yeah, there's also Boulder.
East.
Okay.
Erie?
Yeah, regardless.
Thornton?
Adams County.
In Adams County, okay. So there's been other communities that have been in the paper about conflicts of interest, and I want to make sure that Superior avoids that completely. There's been recently in the town of Superior, at minimum, a perception of conflicts of interest within our town. And as trustees, the way I read the code is that we've got a responsibility, we've got a fiduciary responsibility to address any perception of a conflict of interest as a group, and we've never done that. And it puts us into a bad position, especially when we have residents of the town that ask us about it. And then finally, I think everybody on this board and probably everybody in this room has a different perception of what a conflict of interest is. You ask anybody in here and you're going to get a different opinion. So I'm hoping that from tonight we'll leave this meeting with a better understanding of what a conflict of interest is, specifically with board members, staff, and advisory committees. What are the boundaries that we live within, and how can we totally avoid any perception of a conflict of interest with the public? I have an idea of where we should start tonight, but I'd open it up to questions, comments from anybody.
I'm in full agreement with what Trustee Henson just expressed and explained to us, so we can move forward.
Okay. Well, perhaps we can have a discussion about our code and what our Code of Ethics says, specifically Article 8, and conflicts of interest, and identify if there's possibly any loopholes or misunderstandings of conflicts of interest. Kendra, can you talk to us about a little bit about conflicts of interest and how that pertains to the board, to staff, and advisory committees?
Sure. In your code as it stands right now, your Code of Ethics applies to boards that are boards other than advisory boards. And that really means you as the Board of Trustees and the Planning Commission. And that's it. You also sit as the Board of Adjustment sometimes when you deal with variances, but it's still the same people. So really the Code of Ethics currently, and I know we've discussed amending the Code of Ethics to apply it to advisory committees as well, but currently as it stands, it applies to you and the Planning Commission, and that's really it. I had a chance, I had prepared a memo for you all to discuss generally conflicts of interest, and there are two sort of governing sets of regulations. One is your code, and one is state law. And your code does specifically state that it is intended to be, in any case where it may be more stringent, that's the intention. So, and you have the ability to do that under state law. You can adopt more stringent codes of ethics than state law, or regulations regarding conflicts of interest. So, any place where it does appear that your code is more stringent, then that is what we would apply. But there is, as I pointed out in the memo, there are some state regulations that govern conflicts of interest as well. And I will say right up front, legal conflicts of interest are quite limited. A lot of times what people think is a conflict of interest is not a legal conflict of interest, because it really has to be a financial interest at stake, and there has to be something formal that is coming before the body, a contract, a vote on an application, something more formal than just day-to-day interaction. So in a lot of cases, what may be perceived as a, quote, conflict of interest isn't a legal one. That doesn't mean that you all couldn't address that in some code of ethics, but from a legal perspective, with the regulations you have now, it's pretty limited.
Okay. But as a board, we have a responsibility, though, if there is the perception of a conflict of interest, that we are required to address it, correct?
Not perceptions.
No, not necessarily. I mean, really, the determination of, in the first instance, the person who determines whether or not there's a conflict of interest is the board member who's affected, who is involved in whatever the issue is. Because first of all, even if there's not a technical conflict of interest, if any time any of you feel uncomfortable voting on anything, or you feel that a relationship you have or a contract you have or a past relationship you have, if that ever makes you feel uncomfortable or makes you feel personally like you couldn't be impartial, that's enough.
Okay.
So if that's, but that's your decision, that's a personal decision to you.
So along those lines, so say that you have identified, I own Bob's asphalt company, and we're going to have a contract in front of us for asphalt repair.
Right.
What would be the board member's way of dealing with that?
So when it comes up, let's say we're in the middle of a meeting, when it comes up, you would say, hi, Bob's asphalt repair, I can't be impartial on this, I feel that I have a conflict of interest on this, I'm going to step down. You actually step down off the dais, and what our code of ethics requires is that you leave the room so as not to participate in the discussion at all. And you simply say that, and it's as if you're absent. So your vote isn't counted, and it's not an abstention. It's as if you've actually left the room, which you have, and you're absent for the vote. So that's how you would handle it.
Okay.
Some cities and towns have different regulations about whether or not it's an abstention and counts as a yes vote or a no vote, but it's much less confusing to simply have you absent yourself from the room, and the vote doesn't count. So.
Would you say how we do that when a disclosure might be appropriate? Because disclosure, even if there is not an official legal conflict of interest, there are appropriate times to disclose what may be an actual or perceived.
Sure, that's sort of one step removed. So let's say you're a friend of Bob, who owns Bob's Asphalt, and you say, I just want to disclose that Bob and I have been friends for 25 years, but I feel that I can still be impartial with regard to this decision making. So that's another way. You put it out on the table, you inform people that you have a relationship, so it's not a secret, but then you make the determination, I feel that I can still be impartial in this vote.
But cannot the board then question that impartiality and the board then act?
Yes, in your code, there is a provision, and let me pull it up so I quote it accurately, that allows the board itself to determine if a conflict of interest exists, even if the person who is the subject of the perceived conflict of interest doesn't think it is one, and that would be by a vote. And let me pull that up. So it's under section 2840 of your code. And under subsection B, it says, if a board member fails to declare a conflict of interest, the other board members may determine by motion adopted by the affirmative vote of a majority of the remaining members present at the meeting whether a conflict of interest exists. The motion has to state the basis, and then it's conclusive. Once it's voted on, that's conclusive. So in that case, again, that board member would be required to step down from the dais and leave the room. And again, that's a more restrictive provision than what's in the state law. So that's something that we have adopted locally that is not present in the state law.
Okay.
To go back to appearance of impropriety, as I read section 2-8-30 rules of conduct, going under, let me get this, A4B, it says, no board member shall perform any official act under circumstances that give rise to an appearance of impropriety on the part of the board member.
Right.
So appearance of impropriety is equally important here, actual or appearance.
Right, and that's a different standard. Yes, that's a lower standard. Appearance of impropriety means that, that's a different standard than an actual conflict of interest.
Well, I just want to make clear
Sure.
that that's in our code as it exists, and that if there is that chance for appearance of impropriety, that we, if we're operating by this code, must disclose that because we are subject to appearance of impropriety.
That is correct. And this covers, quote, transactions, and what this says is official acts. So it doesn't even allow for disclosure. What it says is no board member shall perform any official act which would result in the appearance of impropriety. So that doesn't, a disclosure wouldn't help in that case.
So give an example of an official act.
A vote is an official act.
Okay.
Well, then this is pretty powerful, this appearance of impropriety clause. If you can't vote when there's an appearance of impropriety, that's pretty serious. You
That's
know,
correct.
I would 100% agree with Chris that that's the reason we're here tonight, is there are things in our code that give us a pretty strict standard by which to perform our business as board members.
So whose decision is, obviously this is very amorphous, so who's the decider on what's an appearance of impropriety?
And that is not as clear in this case. It does not, this section does not give the board the ability to determine that. It's not clear in here. So generally what I would advise is to the person who is about to perform the official act has to be the one to determine whether or not it creates appearance of impropriety. Because there's no other procedure in here to do that.
And what happens if that disclosure is not made?
You're saying if the board member decides that they do not, that their official act would not give rise to an appearance?
Let's say if simply no action is taken. If the board member who has an appearance of impropriety does not do anything, and simply the meeting is conducted and as if there is none, what then happens?
Nothing unless someone brings some kind of a charge against the board member.
And then what happens?
Then it's basically what it is a code violation at that point. I mean, it's a violation. There are some provisions later about what happens. So under subsection D of that section, it says, oh, that's under the newly elected, but there's really no specific provision about what happens in the case of these transactional violations. There are grounds under state law for removal of a board member for cause. So what you would argue is you can basically bring a complaint for removal. That is done by the entire board against a trustee, and then that would be the basis of your removal, your cause for removal. That's what I would say that really the only way to enforce that is.
So how do you protect freedom of speech and being the minority viewpoint on something, and the majority of the board feels like they don't agree with that, so they're going to vote you off the island? How do you protect yourself from that?
Well, removal from a board of trustees really does need to be for cause. So I think it would actually have to be, there would actually have to be a good basis for removal.
But the good basis is based upon the majority of the board, is that
Right,
right?
exactly. So appearance of impropriety is a very loose standard. So you're right. I mean, really, you have to think about the fact, would we be punishing a minority member for a minority position, or are we really trying to enforce our ethics code?
So Kendra, I'm a bit confused. When can the board cause the decision? When can the board disagree with another board member that they have a conflict? When can that occur?
Well, we're
And
using
when can it not occur?
we're using two separate sections of the ethics code, and maybe that's causing confusion. The first one is conflicts of interest. That's a very specific finding. That's the one that allows the board to make a finding of a conflict of interest despite what the person who's affected by it says. So that's the one where you get to make your own finding. Under this transactional ethics code, that's different. So you would not be making that finding. And again, that's up to the individual board member. If the remainder of the board, and I just located it's under section 2-8-60, that's the violation and penalty. And that allows a majority of the board of trustees, again, if there's one trustee, to have a reprimand of the trustee. If the majority of the board of trustees feels that there's been a violation of any of these sections, that's when the majority of the board could find a violation and either issue a reprimand, or under state law, if there's cause, then there could be removal.
I don't want to which a vote will be taken,
Right,
right?
right.
So that's when it's an issue. It's never an issue over some minor, how many days will something be or when will it occur, whatnot. It's an important issue on which vote will be taken.
Right.
So I'm still confused because you said under conflict of interest, other people can challenge me. If I say I don't have a conflict, they can challenge me, and they're only inclined to challenge me on important issues where a vote's going to be taken.
Right.
But yet under this other section, transactional, you said if I say I don't have one, they can't challenge me. So I'm still...
It's just a different procedure. They can basically go under this violation and penalty section and still make a finding that you have violated the appearance of impropriety standard and subject you either to reprimand or removal. So,
Somebody else understand this? Am I just a little confused?
I think the code is not well-written in terms of this and probably needs some buffing up, because it seems like to protect a minority viewpoint on something,
right.
even if there's not a, and once again, conflicts, I mean, everybody up here has conflict from time to time just because it's, you're in the community and we vote on things that are important to people, so. But if you don't identify a conflict, or if there's impropriety, it would seem like it would be better to have a third party be the judge on who is, if there's really a conflict. So I would think that would be municipal court.
I haven't seen municipal court decide it, but that's an idea that we could certainly look into. In some cases, you can have an independent third-party consultant, investigator, that kind of thing determine an issue. But a municipal court is another great idea. I just haven't seen that before. But there are provisions in some codes that allow the board as a whole to vote to go out and hire someone to look into it.
Because clearly we want to do what's the right thing. People should identify if there's a significant conflict of interest, i.e. a financial one in a contract that we're going to sign. And if you don't disclose that, there should be some penalty versus, but not a penalty where people just disagree with you. So.
And that is a difficult problem with this appearance of impropriety standard, and that's why some communities don't have this in the ethics code, and that's also why the state law doesn't have the appearance of impropriety, because it's amorphous, and it can be used by a majority against a minority.
Which would be a very unfortunate circumstance. So
Exactly.
I guess from my perspective, depending on how this is all going, I'd love to see what other communities do and see if there's a way of getting, some more, less a subjective and more an objective way of dealing with this.
Right. Because conflict of interest is much more objective. Financial interest is well defined. The state law has it, your code has it. Conflict of interest is pretty straightforward. But once you get into the murkier area of the appearance of impropriety, that's when it
Right,
starts to
because
get murky.
right. You could say, well, there's some project that's going to be happening across my street,
Right.
and I'm going to vote against that because I don't like that. Is that improper? I don't know.
Right.
So it seems, once again, very subjective.
I agree with you. So.
Is it appropriate to bring a real example at this point?
I'm happy to look at hypotheticals. I guess my preference is if you want to talk about real examples and get my advice as to whether or not it's a conflict, I think that's probably more appropriate for an executive session because that would be giving legal advice. I'm happy to hear hypotheticals. I'm not trying to stifle the conversation we're having here, but I also...
Did you mean, within the board here, or
Yes.
did you mean somebody?
No, I think we have a real example here, and we just want to find out, is there a conflict? Is it just an appearance of a conflict of interest? Is it a real conflict of interest? And this is what has brought this about. So this is not a witch hunt. This is not, taking it out on one trustee. It's basically wanting clarification to understand. I'm not a legal expert. I don't know, but I just want to find out if there is. Okay, let's deal with it, and if there isn't, then that's fine too. And it's good for all of us to know that. It's good for the public to know that as well.
So Kendra, under our rules, our code, at any time if we felt that there was a conflict of interest, then we'd have to break and go to executive session and discuss it? Is that what you're saying?
Not necessarily. It doesn't require to go into executive session. So I'll give you an example. If you're going to vote on the paving contract again, and you realize, okay, the mayor has an absolute direct conflict of interest on that. We'll use that as a hypothetical example. Before the vote, you can, or before the matter even comes up on the agenda, you can state on the record, Mr. Mayor, we think you have a conflict of interest in this case. Sorry, I'm using you as an example.
Pick on me. Beautiful. I wish I had a paving contract.
You can say, Mr. Mayor, we think you have a conflict of interest. Now is your time. Are you ready to recuse yourself and leave the room? If the mayor says, no, I don't believe I have a conflict of interest, then you can say, we would like to take a vote on this right now. And if the remainder of you determine, you know what, Mayor, you really do have a conflict of interest, and here's what we think, and there's a motion and a vote, then you're required. Don't ask me what happens if you refuse to leave, because I don't know at that point. But you're required legally to get up and go in the other room. So.
What role does the attorney play in that? I mean, since you're the expert in the legal conflict of interest versus perceived, et cetera, if we find out Andrew's brother-in-law owns XYZ paving company.
Right.
Okay? He doesn't recuse or disclose,
Right.
remove himself, and we say, you got to, and it becomes contentious. At what point do we go to our attorney and say, okay, you arbitrate here?
Sure. So at that point, we probably do an executive session to receive legal advice. But I can't be the one. I'm not allowed to be the one to make the determination in that case necessarily.
You can advise us in what the law says.
Exactly. So I would advise you in executive session, you would come out and then again have your motion and your vote. So that's how it would work.
And is there some standard, obviously if my Uncle Fred, who is a, accountant with the global-wide Bob's Contracting Company, and he works in California, that can't be the same as my wife is actually the major partner. So is there a degree of relative?
Yes,
that
and
has to be?
if you go to the state statute, it has a pretty good discussion of what substantial is, and talks about what substantial means. And I have had cases in other communities where there's distant relatives or somebody working in the mailroom at a huge corporation, and basically what we've determined is somebody working in the mailroom at a huge corporation, their vote probably on a particular matter relating to that corporation is probably not going to affect them financially. If we discovered the next day that they went from a mailroom job to CEO, then we might, then we might reconsider that. But there are certain levels of financial interests that probably wouldn't rise to the level of substantial.
And did you send the state
Yes.
definitions to us?
Yes.
Oh, really?
Yes, and I'll just read it to you. Substantial interest is an ownership interest in a business, a creditor interest in an insolvent business, an employment or prospective employment for which negotiations have begun, an ownership interest in property, a loan or debtor interest, or a directorship or officership in a business. So.
So can we, Chris, would you mind if we went to some recommendations of what we would like to see regarding, I would like to go back to the beginning, and my interest in conflict of interest is broader than just the Board of Trustees. My interest in conflict of interest is three parts. One, I believe we as a board need to review the conflict of interest with senior staff. Senior staff at companies I've been associated with all have to sign conflict of interest disclosures annually to say they're aware of that government's policies and procedures, they agree to abide by them, et cetera. And I would like to see that incorporated here. It's not already incorporated here, but I don't feel we have to resolve this issue in its entirety tonight. I think we can take it on to other forums, but make it a priority to get it resolved. But I think we need to review conflict of interest provisions as they pertain to at least senior staff or any staff of a level to be spending town money, basically. And then I would like to, as I said in the commissions and committee meeting, I would like to have the conflict of interest disclosure at the advisory board level. When people apply, I would like them to state what anything they know of that might present conflict for them, maybe with their job or with their husband's job. Obviously if somebody has a job in anything to do with landscaping, park management, recreation management, open space management, and whatnot, I think it would be prudent to disclose that. It may not disqualify, but I think it's always prudent to disclose. And then there will be votes taken at the advisory committee level that may involve a conflict or perception of a conflict, et cetera. So I would like us, by the time we're finished with all this, to address those in all 3 levels.
Sure. And I
No,
think
I agree.
this
Yeah.
goes back to the discussion we're planning to have about advisory committees and their roles as well. This all ties in, because I think the purpose of not having this apply to advisory committees is because advisory committees are advisory, so all decisions come back to the board to make the final decision, and therefore the conflict of interest rules wouldn't apply to those boards. But that certainly can be changed. I just am trying to offer the basis for which that was distinguished, advisory boards and commissions versus boards and commissions that have votes that are binding and can bind the town. So,
But if I can get back to a couple of recommendations I would like to put forth tonight. One, I do believe that it's smart for us to incorporate that annual signed statement across the board for senior staff or staff with any money spending authority and for advisory committees, that there are pro forma be made, that we all sign off and have to read annually, so we are alerted and aware annually of what our responsibilities are. And I actually think it would be prudent to have a short, 1-sentence statement that is read when the mayor introduces the agenda. That's read that please be reminded that we all have an obligation to disclose any actual or perceived appearance on any action before us, et cetera. That reminder, both here and at the advisory and planning commission level, just serves as a simple reminder of our responsibilities, and I'd like to see it incorporated.
and that's certainly something that you are legally authorized to do if the board so chooses. So,
Any feedback on that?
No, I'd like to hear from some of the other board members, too.
I wanted to get a handle on what you were talking about disclosure-wise as far as somebody applying for a committee and being related to doing landscaping or anything.
Well,
I mean, you can't, that's just too broad.
Well, no, I think, of course, it comes down to, one, we interview these people, so we can ask
Yeah.
the questions. We can say, do you have any, or is anybody in your immediate family directly involved in X, Y, or Z? So we can direct some of that. But if we have that on that application form, that if, please disclose any direct familial relationship, please disclose this, that we can guide. And of course, it's all at will anyway, but I do think.
And going beyond any
Yeah.
disclosing that somebody either works for or has a family member that works for a company that does business with the town or works for the town, I don't see where you can go with that. I mean, you can't claim a profession or a job type is a conflict of interest. That just doesn't make sense to me.
Well,
That's overbroad.
whatever makes sense to disclose, I think we should ask to
So
disclose.
that's related again to conflicts of interest. And all of the things that we're talking about, conflicts of interest, again, there's always a trade-off here. Number one trade-off is if it's overly broad or you're not going to get people to work for the government or the willing to do this. Number two, I've even lost my train of thought on what the appearance of a conflict or the appearance of impropriety, that's still got to be tied to something in the code. And right now, that section is, I think, the section where the board steps in relates only to conflict of interest, and conflict of interest only relates to financial interest, and financial interest is pretty well defined in the code. So,
I think you're right. I think your current code does
my
find
other
conflicts.
point is the point the mayor was making about free speech, and we can't have this potentially carrying over to a minority viewpoint, such as we all heard in a meeting once that a different viewpoint was considered a conflict of interest in a broader sense. That by no means should ever be what we're talking about, and we can't have this become a tool for getting there.
And perhaps, I agree totally with the mayor that there are some modifications needed in there. And frankly, the appearance of impropriety maybe is too broad in here and needs to be tightened up. And I would challenge us to try to define what you just described in here, that this does not include whatever wording, and we can borrow from other towns or the state on minority viewpoint, and we attempt to quash a minority viewpoint. So we can give that an attempt.
Joe, you said that financially, that's a pretty clear-cut case if there's a conflict of interest. But it's not for me. If a trustee receives a grant, is that a financial, where does that fall?
That's financial in my view, but
Okay.
that may not be clear to everybody else.
Well, it's a grant from the town.
Yeah, I
No,
guess.
I'm just asking, I don't know. Is a
If the-
grant,
if the
isn't that
town-
money?
Yeah,
If money is exchanging hands
from the town.
from the town,
And
or
only the town?
I'm sorry.
And only the town?
No, well, I'll use another example. Let's say someone is coming forward with and wants to get one of the town's contracts. We'll use paving again, okay? And then the paving contractor suddenly gets someone to give a grant to one of the trustees. That's going to be a conflict of interest
Okay.
because that's a direct financial benefit to a trustee in exchange for a vote, basically. I mean, I don't want to use the term bribery, and I don't think this would actually happen. I'm going to the extreme to make the point. But if a board member gets a grant because they're going to vote a particular way on a particular issue, that's a problem. That's a conflict
Okay,
of
that's
interest.
all I wanted to, yeah,
Yes.
okay. Just want to clarify that.
It does get very gray also, though. Because people who take money from people while they're campaigning,
Right.
I think that we've seen, especially in federal government, you receive campaign contributions from the insurance company or from who knows what,
Right.
which, that's a huge conflict of interest in my mind, but that's not how the federal government looks at it at all.
Or
Well, and we also have
our code
yeah,
against
we
that,
have an
too.
exclusion for legal campaign contributions.
Right.
So that means reported campaign contributions that are disclosed as they're required to
They
be.
are disclosed.
Yes.
Yeah, they have to be.
Right. They have to be disclosed to the Secretary of State's office or wherever the disclosure needs to go, and then those are excluded. So,
Right, and those are all public information. You don't have to lie in.
exactly.
So let me ask a question on the conflict of interest. In the Town Code Section 2-8-20, in definitions, it says, conflict of interest means a personal or financial interest of a board member that interferes or influences or may influence the performance of his or her duties on behalf of the town. Say my area of expertise is computer tech support in IT. And I own a business, and there is a contract that is coming forward to the town. And I sit on the board of directors for that contractor. Is that a conflict of interest? Is that a personal and financial conflict?
That would be. So you sit on the board of directors of the company that will actually be contracting with the town.
Correct.
Yes, that's a conflict of interest. Because you, as a director, would be getting a financial benefit. I'm assuming that's, your company would be getting a financial benefit from the contract with the town directly.
What if that benefit is a grant? Again, is that a conflict of interest?
The grant makes no difference. I don't know, the form of money how the money comes makes no difference. If I'm answering your question.
And even to carry it a step further, if you were on a board of a nonprofit, that still would apply if the nonprofit were in line to get a grant.
A grant from the, I'm trying to figure out where these
Yeah, I mean, it all
grants are
depends where
coming
the
from.
grant's coming
Yeah.
from. I mean, that's
Yeah,
part of
from the town.
Right.
We're voting
Grant
on it.
from the town.
Right, if it's a grant from the town, but yes, if it's from the town, yes. Now, that also goes back to, it also depends on a nonprofit, it's a little bit different because it depends if the directors are paid, and if they're paid for their service. Because often directors sit on boards of nonprofit organizations as volunteers. So in that case, it may not be, because there's absolutely no direct financial benefit to the director. If they're volunteers on a board of directors for a nonprofit foundation organization, then there may not be a conflict of interest.
So what if you are the sole owner of that nonprofit?
Again, if you're
Then
not
how does
receiving
that-
any pay, if you're the sole owner of the nonprofit and you're taking income, if you pull income out of that nonprofit, then yes, it would be a problem. If you are pulling no income out of the nonprofit and you are really running this for a benevolent purpose and all income goes back out to your employees, then no conflict, because there's no financial interest for you. So it all depends on how you're getting compensated.
Well, you have a financial interest if the grant is helping keep your company afloat. If your company is staying in business because the grant is coming to you, then of course you have a financial interest in that. What we're doing here is we know what we're talking about, but we're dancing around the issue, and we need to be able to discuss specifics.
And that
because
is, I've
we're
told
doing,
you we can do in an executive
yeah.
session.
So we need to make that happen, because I want to make sure that we're clear. That was the purpose of this meeting, so that we leave here with clarity. And again, this isn't about a witch hunt like Elia said. This is about us understanding what our boundaries are so that we totally avoid those boundaries.
I understand, but I just want to make sure any specific, if we're talking about a real situation, we do need to talk about that in executive
Yeah.
session.
We are talking about a real situation,
We
yes.
are, and also, we have got to understand this ourselves. So when we get calls from residents in this community, whom we represent, we
Sure.
can answer those questions with accuracy.
Sure. I understand. I think, my understanding was the purpose of tonight was to go over this generally and just have the discussion we're having right now. And if we need to move on to the next step and have a specific discussion, I would just recommend that we do that in private, and then after that, the board can take whatever action the board chooses to.
Yeah, I think that needs to happen, because we could say hypotheticals all night, but we still may not be getting it clear. So I think we do have to be very specific about what we're talking about. That's the purpose of this meeting.
Can we move to executive session now to discuss it, or?
I don't think it's been
That
posted.
wasn't-
It's not-
Because it's a work session.
It's a work session,
as
and it
opposed to
wasn't
a special
posted.
meeting.
We're all learning here.
No, I understand.
Okay, good enough.
I'd like to, again, if Sandy could summarize the points she was looking at achieving, including what our subsequent conversations were, that would be good, because I think you're on track for some specific actions that
Right.
might make some
Well,
sense.
and I would like people's input and additions, or tell me I'm all wet on this, but the first thing is, I believe, across senior staff, across all the members of the town board and the membership of our advisory committees, that we all are given annually a statement that defines our policy. We must read it, and we must agree to abide by it. So that's just an annual reminder that we are governed by
a set of laws. Sorry. And then I would like maybe you, Kendra, to compose a pre-meeting statement that the mayor reads and the committee chairman or planning commission chairman reads as part of the introduction of every meeting, that reminds us that we will be making decisions tonight that may involve perceived or actual conflict of interest, and to, as appropriate, disclose and/or recuse yourself from any vote in which you have a conflict. So that meeting reminder. Anybody else?
I'm not on board with the meeting reminder. I think that's kind of overkill. I mean, we all know, we're here to serve the community. We've talked about it. I do believe we need to have an executive session, perhaps on Monday, if that's doable. I don't know if we have to publish it. Is that possible to do it this coming Monday, or do we have to wait until?
Well, obviously, my suggestion was to hold this on a Monday, but it couldn't wait till Monday because I'm not sure why, so it doesn't sound like Monday can work.
No, Monday
have
can
an
work.
executive
The
session.
meeting originally was called so that we could have an open discussion about conflicts of interest. And by posting it the way that it was posted and having it in this format, that it's prevented us from having the open discussion that was originally intended. So we can certainly have it at a board meeting and an executive session. I'm all about that. But again, remember, the original intention of this meeting was so that we could be open and frank with each other and talk about conflicts of interest so that we avoid them.
I like this, doing it on Thursday night, because we're not bound by time constraints. We can give this as much time as we determine and as the membership in the room, the residents in the room determine. So,
Kendra has a little voice she needs to put to bed, so, you know, yeah.
I have a time constraint because I have to pick up my daughter.
No, I know.
Sorry.
So we say we're going to try to do it for an hour, but can we have an executive session? We need to have one, clearly, and can we do that this coming Monday is what I'm asking.
If that's the only way we can have the discussion that we want to have, then yes, we should.
Well, the specific discussion,
Yes.
I guess that's the only way to do it, so,
Then let's request an executive session Monday night.
okay.
So Monday on an off meeting night?
No, this coming Monday.
Well, this coming Monday, you actually don't have a meeting because.
the next meeting,
So
the
November
next
14th
meeting
is your
night.
next meeting.
Right.
So
Yeah.
there'll be plenty of time for that one,
It's okay. So there you
if
have
there's
it.
time.
Unlike,
Somebody second that so we can make sure.
No,
second,
you can't vote on this anyway.
It's a meeting anyway.
oh, okay,
Just want to make
whatever.
sure that everybody's on board.
head nod. I'd like other people's opinion on whether or not the one-sentence reminder at every meeting is overkill.
I think it's important, especially if there's a big topic that we're discussing in the advisory committees, and specifically with, OSAC recently had conversations in that advisory board with the Hodgkin-Harris Reservoir. I think that we do need to have, in meetings like that, where you start the meeting off with that sentence, and perhaps in the board meeting, too.
Every meeting.
And then maybe that's the responsibility of the liaison.
I don't know.
First, we have to get this to apply to boards, advisory boards.
Right.
It
Right.
doesn't apply to them right now.
Right.
Have we had first reading on that ordinance yet?
No.
No.
We have that prepared, and it literally just changes the definition of board in your ethics code to exclude the words excluding advisory boards, so that it will apply to all boards.
Right.
Clearly, this meeting has garnered a lot of interest, so I would like to hear from the public, since they're, if that's okay.
Before we do that, the other thing I think we were talking about was possibly wrestling with this language regarding appearance and trying to nail that down a little more specifically so that it's...
Would you like to have a work session on that to discuss how you want to address it? Because I just don't know
think
what
we
to
need
draft
see
for
some-
you.
Yeah, rather than draft it out of the black or out of the blue, or us dream up things that, we should see what's out there.
Okay.
Do you have
Yeah,
examples
right.
from other towns?
Sure.
that
Yeah.
you-
We can get them.
Okay.
But then we could do that in a work session and then go a step further. But I really, I've had this as part of my career, and appearance of evil is, in the eye of the beholder, and it's best to have some context of what we're talking about.
And in my experience, that's why some communities have actually gotten rid of this, because it's so
Amorphous.
amorphous, exactly.
And then that other thing we discussed where between official acts and conflict, what you and I were discussing here
Right.
about when can other board members publicly challenge whether or not another board member has a conflict or not, and make that totally explicit to where there is no confusion when it doesn't occur.
Okay. So would that be something you would like to talk about again at a work session, or would you rather,
I'm good with that, or at a retreat.
or at a retreat? I'm throwing out work session, but obviously retreat would work as well. Okay.
Okay.
Then going to the public now is okay.
Okay.
Anybody want to speak about this?
James has
It
something to
is
say.
flabbergasting to me that you want to say something.
I know, me too, right?
As unaccustomed to public speaking as you are.
So much to spew. James McInnes, 2187 Graydon Court. So my involvement with the town goes back to 1996, was the first time I ever came to the meeting here. I spent from 98 to 2000 on the town board, where that ethics provision was added to the town code. And I spent 13 years, 10 years, 11 years on the planning commission. And I got to tell you, this feels like you're really just setting yourselves up to, A, be able to bully whoever you want in the room, and B, absolutely eliminate any public participation in any of your advisory boards. There's not a single planning commission member currently that could be said to never have a conflict of interest. And the people who are most interested in the things that you want to be advised on are people who work in those fields. Real estate agents sitting on the planning commission, for instance. Landscapers sitting on the OSAC committee, whatever. It makes absolutely no sense to say that you need to disclose at the front of every meeting that you're a real estate agent and you're sitting on the planning commission. And is there a direct correlation? You know, the thing about the definition of conflict of interest is it's very narrow. It talks about personal financial gain to you as a result of your activity today, right? And it only applies, by the definition of the code, by what we've talked about in this room tonight, it only applies to people actually making the final decision, you people. Has nothing to do with advisory boards. And I find myself getting angrier and angrier as I stand here, because I feel like part of the reason that I quit the Planning Commission is because you guys have done everything you can to bully, marginalize, and otherwise stop listening to your advisory boards. And this feels like yet another step in that direction. And if your goal is to have no one working with you to help you make decisions and to do it all yourself, you are totally going in the right direction. And if this is about something else, if this is about being able to bully a specific board member, then yeah, you're going in the right direction. But a conflict of interest is the responsibility of the board member to disclose. It's not something that you can go jump up and point your fingers and say, well, you're in conflict because... Right. That's not a decision you get to make. Not by our code, not by the state code. It has a self-disclosed proposition. And for us to be, I feel, I'm flabbergasted that this is what we're spending this evening's work session on, that this is what's taking up the board's time. In the whole history of my being here since 1993, no one, not one person, has ever actually had a conflict of interest that was deemed worthy of anything more than recusing themselves. And, by the way, having an ex parte discussion with a developer, right, about their particular whatever it is before you come to a board meeting, that's a bigger problem than whatever Lisa's perceived conflicts might be, right? Taking money from those guys in the form of campaign contributions can be a bigger problem than your nonprofit company getting a grant from the town to do the work that it does anyway, that the town needs to have done because you're the expert in the field and you're here. So it feels really unsettling to me that this is the conversation that's being had. And, you know, most of the folks sitting here, I think, are probably in favor of less government, and yet here we are making niddly little picking at nits while we have 80% of the Superior Marketplace empty. So I just encourage you really to let the code be the code and work on stuff that actually will help the town. Thanks.
Thanks.
Steve Smith, 653 Eaton Circle. Mr. McGinnis will probably have a heart attack that I agree with him. Because he and I intellectually have gone and sparred and respected each other intellectually over the years. And I do agree. I agree that the board, the people who advise you, shouldn't be in question on a lot of these things. However, he did make the statement that when you are actually a trustee for the town, and if this is what this discussion is about, then the rules are different. And I agree. And I have a couple of things, because I'm not bound by executive meetings. I have something called freedom of speech that allows me to speak tonight. And one of those things that I want to bring up stems back to when I was on the HOA board, and when I brought to the town what I felt was a conflict of interest, and that was the trash contract. And again, recently, I've seen the trash contract come to light. I've seen some advising on the trash contract. Recycling is only 29% in this town. And I just read this in this last meeting on Monday. So I took it upon myself to call Waste Connections, who does a recycle bank program, and they were kind enough to send me an email that, again, it's a conflict of interest on the information in my mind, that the recycling in this town in October for last month was 45%. That's a significantly different number than the 29% that's being represented to you. In addition to that, you talk a little bit about what's going on in the town, and everybody pretends up here that nobody knows what's going on, but we do. I do, because there was a public letter dated September 26th by Lisa Skumatz talking about this new E-Conservation Institute. Okay? And I've always been suspicious because of the close relationship of the recycling and all of these companies, so I started to delve into that. And the E-Conservation Institute has a Secretary of State filing by Lisa Skumatz, which received a grant for this, and she's recommending that we go ahead and take a look into this situation to actually have the E-Conservation Institute follow down this chain of command on this food processing down our drains. So I went a little bit further, and I said, what did the E-Conservation Institute, knowing that she filed this at the Secretary of State, and I looked and I got a copy of the Articles of Incorporation for the E-Conservation Institute, and it was sent on a fax machine on July 16th from SERA, which are initials for her for-profit organization that she owns. So I started to look at that and say, now we've got a nonprofit that's owned by a for-profit organization, and I looked a little bit deeper, and the question here is, I don't know about conflict of interest, but if you follow this chain, and then all of a sudden you start to look at the pay-as-you-throw program, the contact person for that organization is Lisa Skumatz. So I went a little bit further, and I found corporation after corporation after corporation that advises each other that all of the contacts of these corporations throughout the county of Boulder is all Lisa Skumatz. So the question is it a question of perception? Yes. I perceive a conflict of interest. I see a conflict of interest in the letter that she is not gone through the due process of actually going through a proper RFP, that she gets to write a letter directly to the trustees of this community that I have, that was given to me, okay? And this was in a public meeting, by the way. I was paying very close attention to what was going on, okay? And one of these pieces of paper was left in this room. So it must be public if it was left here, and it must not have been important, okay? So there is a perception of conflict of interest with this town, and I think this town needs to address it. Thank you very much.
So I just want to be clear, so Trustee Skumatz has a contract with the town? I'm sorry.
No,
I
she
missed
is
that part.
recommending that the town enter into a contract with the Conservation Institute to do a study on the food that we're processing down our sinks. So that is one thing that's brought up. The second thing that was brought up that's very irritating is this trash issue is coming up again in this town. I have always believed that the trash contract should be in private hands in the HOA, and I believe it because if it goes into the public's hand, or into the town's hands, it then becomes a process of a way to charge people more money, and that's taxation without representation. Even Bill Clinton in Washington, D.C., that was his bumper sticker when I was out there for the Washington people, was taxation without representation. I believe that this town should not be handing those type of things over to the government, because it is an opportunity to charge. The information that you're getting that was in the last meeting Monday, that it's a 29%, is misleading. I don't know where the information comes from. I'm looking into that too. But I want the town to know and the officials to know that it's a 45%.
So just so I can be clear, so there's no contract that you're aware of?
No contract that I'm aware of. There's a recommendation for a contract.
And you're mad about trash contracts? Is that sort of the summary? Okay.
Yeah. Thanks for making me feel belittled for it, but absolutely.
I just wanted to be clear what we were talking about.
Crystal.
Yeah, but I think that was disrespectful, actually, honestly.
I just agree.
Well, when you said something, you're mad about the trash, when it took several minutes to explain where he was coming from and what he was thinking, I don't think that's the way to treat a member of our community, actually, who has served diligently this community. To say there's a difference between the 29%
Trustee Skumatz has worked hard. below the...
Okay, you can be sarcastic if you want. I'm not going to get into sarcasm. I'm just talking about facts here.
I don't think I'm being sarcastic. I'm just making a point.
Okay, well,
Is there
I don't
more
want to
public
play
comment?
words back and forth like that, but I'm not finished yet. To say that the 29% is not accurate as it was presented, it caused a lot of suspicion among several board members when that came up when we had the presentation that Lisa. I like the rest of the presentation, but that number didn't make any sense to me. I think the 45% that comes from the source that actually collects our recycling is much more accurate. For Steve Smith to bring that up, he's not doing anything wrong with that. He's just
No.
bringing up the truth. That's all he's saying.
Yeah.
Okay, so
But we were talking about conflicts, but, okay.
Dana D'Souza, 1752 El Dorado Drive. And actually, just to clarify something that Steve had said before, e-conservation is not receiving any money, as far as I understand, from the town. And so it seems to me that there's no vote and there's no money from the town, and I think we've already heard from the attorney, then that would take it out of being a conflict of interest. And when you say there's no witch hunt, then I wonder why you're continuing to go with the same line of questioning. The other thing, too, is that I really hope that when you do go to this executive session, that you take a look at each individual member up there and whether or not you voted maybe for open space that you could see from your bedroom window, or if there's perhaps a conflict of a property across from you, or if you have a close friend who owns a business that may have benefited from a business development plan. I mean, I think there's a lot of different things that if we all wanted to get nitpicky, we really could, and I think we need to be really clear before we try and prosecute someone on something that is really just perceived. When I was on the board, I worked for the YMCA. Our town had a contract with the YMCA. I vetted it in the open. I went through the town attorneys. And I reclused myself from the vote on that one. But I did not have a witch hunt because, frankly, I think the board was much more trusting and certainly willing to be open to these sort of things and realize that each and every one of us has, in a small town, certain things that can be construed a conflict. So I hope you take a close look at that on the meeting.
Dana, I agree with you that if there is a perception of conflict of interest on any person in this town, then it should be brought up and it should be discussed. That's what this meeting is for, so that we understand where those lines are. And I agree with you. And
And Chris, if I can
address what you and I have discussed personally. We were new members elected to this body and never were educated on what conflict of interest is. The reason we're here tonight is not to throw some definition out that others need to abide by. It's to be educated ourselves so we know what we need to abide by ourselves. We're not inflicting this on anybody. Primarily, we're inflicting it on ourselves and being properly educated as to when, and I admire you, Dana, because of what you did on that, is there was a perception, you brought it forth, and you recused yourself, and that was a proper course of action. So I want to know when I am in that same situation, what I should be bounded by and how I should act, and I think you acted properly, definitely in that case. But this is not about foisting on anybody. It's creating a standard by which we ourselves will abide.
Bob McCool, 312 West Coal Creek Drive, and a member of the Planning Commission and on a couple of, or I think one advisory committee at this point. I'm disappointed and flabbergasted. I don't know what's going on. Clearly, I have some sense of what's going on. I'm shocked that we're here tonight in an emergency session for it. I do wholeheartedly agree with what James, pretty much ditto his comments. This town has tools to deal with situations of impropriety, and they have tools to deal with situations of conflict of interest. You have tools to deal with your committee members if you think they are problems. And all I've been seeing over the last month is this intense need to put in more rules and more. I don't get it. I really don't. You're scaring me away. Maybe that's your intent. Maybe you want to get rid of some of us. I don't know. But if you're going to start putting, I have no decision-making authority, even on the Planning Commission. Everything's recommendation now. The Planning Commission. We don't have any authority to do anything. James is absolutely right. As an advisory committee, you want to hear anything I can come up with, tell you, anything that I can think of, whether I have a conflict of interest or not. I'm an advisory. It's an advisory position. There is no decision-making authority. And when I hear what's going on with what's happened with the advisory committees and term limiting this, and if you have problems with situations, you have the tools available to you today, everything is written, to deal with them. James is right. We haven't had a serious conflict of interest in this town that I can remember, ever. And we're a small community, and we're acting like we're some huge municipality that can't keep in track of who's who and what's what. Clearly, we can. There's enough going on here that people paying attention that we can see if there are issues, and they can be brought up in this forum. And Mr. Smith has every right to do that. I don't know whether he's right, wrong, or different. I don't think I do, because I know and trust and believe in Lisa, but I don't know. I don't know. We have the forum to deal with it. We have the ability to come up here and talk to you and present issues like this so that you can talk about them. Why are you changing rules and trying to put advisory committees on notice, basically, is what it kind of feels like? But I got to sit and listen to. I know what conflict of interest is. I was advised as a planning commissioner what those rules are. I would expect that somewhere in your packets of information that you were given that those are fairly clear, and you should know what they are. And when I sit on the planning commission, even though I don't even have any decision-making authority, I am very sensitive to whether I'm making a decision that I have a conflict of interest with, even if it's because I live next to George and I have an issue with, something that's coming up, against George or with George, then I'm very sensitive to that. And I think we all are, because we're a pretty good, solid group of people in this town. We care about each other. We care about ourselves. We care about our community. And I don't think we need this, wherever you're going with these rules, to make it more difficult for us to work together, because that's really what you're doing. I'm very nervous about where you're going and what you're trying to accomplish.
I don't think that's the intent. I don't think that's the intent, to make things more difficult for you or for anybody else who serves in the communities. We're actually very grateful for the advice that we get, so I don't want you to walk away.
I'm not feeling that way. And
I
I'm
understand.
not seeing that in the behaviors that I've been seeing over the last 60 days. I'm not seeing it. I hope that's true. I do. I have the utmost respect for everyone up there and what you're doing, and I voted for just about every one of you. So be careful. Joe's got a really good point. Listen, it's been around a long time. Just tread cautiously and carefully, because you're going to scare people away.
Yeah. Can I address that real quick? Bob, I appreciate your comments. James, I appreciate your comments, too. That's the beauty of this town, is that we can talk openly amongst each other. Bob, you mentioned, both of you have mentioned that the advisory committees quite a bit in your comments. And this thing isn't about the advisory committees. That is just a thought that we had, that maybe we include the advisory committees in this process. The conflicts of interest is a much bigger thing. And I agree with you, Bob. We have the tools to deal with this. But I wonder, how do we deal with it? If, as a board member, and I think that there might be a conflict of interest, how do I address it? Do I address it in a meeting like this? Or would you rather me go in an executive session every time to do it? And I don't think that's the proper venue. If we see that there's a conflict of interest, we have the responsibility that all of you have given us to make sure that there isn't a conflict of interest. It's a simple question. And if we're having this argument right now on this board, if Joe doesn't think there's a conflict of interest, I think there is, Andrew doesn't think there is, Sandy does, then there's a problem, because we're certainly not on the same page. It's not a witch hunt. I want to know the answer. Where is it that we draw the line?
Since you're responding to me, I'd like to respond back.
Okay.
I would not want this conversation in a public forum at this point. If we had all kinds of issues with our town and conflicts of interest were coming out our ears, and the public needed to be involved in them, maybe, and that's a maybe. If you have differing opinions about an individual board member and a conflict of interest, I do believe you should discuss those in an executive session.
Okay.
And I do believe that you should work those out, because I trust that you will do that. That's why I elected you. I trust that you will do that and it will get handled. If there are enough of you up there, that it will get dealt with properly. I don't believe that needs to be vetted in a public forum. I think it's inappropriate and improper. That's my opinion. So, but yes, and I do agree with you. You need to understand when it's appropriate. I believe you have the tools to do it. I think you should take advantage of those. If that's what's going on, by God, all means, please, I want you to go in and talk about this and figure it out and determine whether we have a problem. That's why you've been elected to do this.
That's right.
I don't think it should be, I don't know. I don't think we have a big enough problem in this community. But we need to be, because if you're wrong, then you put something through a public process that you had no business doing. Okay, that's kind of where I'm at.
Okay.
And Bob, I completely 100% agree with you on that, and I do want to see an executive session at the next board meeting, because I think that's where it belongs, and it is something that we need to work out, as well as find out if there isn't an issue or not. And if there's not, we can move on and continue on. But I think it's important to understand what the issue is, if there's a conflict, because none of us up here would want to repeat that if it is a conflict.
So can I respectively ask I know there's more people want to talk, but I want to respect the attorney's time who had to actually bring her child here to a meeting, and so if that would be okay, I'd like to wrap that up. Would that be reasonable?
So we're over the hour.
I
So.
have about 10 or 15 more minutes till the movie's over.
All right. All right, movie's over, Kendra.
Thank you.
You're good.
Okay.
Thank you, Mayor.
Yep.
John Nybarger, 1514 Waldona Way. I had 2 points that I wanted to make real quick. The first one is with regards to advisory committees. As you probably all know, I sit on the Boulder County Commissioners Park and Open Space Advisory Committee. And when I was appointed to that board, I had a big worry about conflict of interest, and a lot of that came from because I didn't understand what conflict of interest really meant. I think that the attorney obviously explained it very well, and was this was explained by the county attorneys as well, and also by Ron Stewart when we had our first our introductory meeting. And my concern was, if I'm sitting on the county board and we're voting on something that has to do with Superior, is that a conflict of interest for me to vote, for instance, in favor for something in which funding would come to Superior? And I was worried about that. I didn't want to have any perceived conflicts of interest. And both Ron Stewart, the director of Parks and Open Space, as well as the county attorney, said, if you're not getting any money for it, you don't have to worry about it. Wow, this is great. I can be an advocate for our area. I can be an advocate at the county level for us to get parks and open space funding that can maybe come to Superior. This was good. I should understand a bit more on the importance of the conflict of interest and then the role that I can play at the county. So that was my first point. My second point is, I've lived here for 10 years. I've been volunteered for the first year on OSAC before I was appointed. Showed up to the meetings even though I wasn't a member. A year later, I was appointed, became vice chair and then a co-chair and then chair for a number of years. Also in 2003, I was appointed onto the ProStack committee, went through the whole ProStack master plan process. There were only 2 of us who ended up staying on after the entire committee quit because of the aftermaths of the master plan report. Bob McCool was the only other one. I'm still on that committee. I'm still on OSAC. I wonder how long I'm going to last through this. The last 60 days? I'm just flabbergasted. All the time that I've spent in the town to help this town, to see it move forward, and I'm really, really proud of a lot of these accomplishments, but what's going on here? I just don't know. I just don't know what to say. I mean, this echoes Bob's and James's comments, I know, and I don't know what's going on. I hope this can get figured out because I really care deeply about this town, and I volunteered a lot of time. And maybe it's just time for me to spend more time with my kids. I don't know.
John, you have served this community for so many years, and we're indebted to you. I still don't understand what the 60 days is about. This keeps coming up. I'm not aware of what you're saying this last 60 days. What's been going on? Because I'm not aware of that. So clearly, either we're doing something that is affecting you guys. I don't know. Are you talking about here tonight, or are you talking about something that's been multiple incidences where you feel like you're taking for granted? Or please explain. What do you mean for the last 60 days?
I think it'd be better to
No,
talk
we can do it
offline.
offline. That's fine.
I'd be
good.
happy to
Yeah.
talk with anybody about this. So.
Okay.
I
That's fine.
could just say that in the last 60 days, aside from this discussion and the discussion about extending the rules to advisory committees, we've also had a meeting with advisory committees talking about defining rules, how to conduct meetings, whether Robert's Rules of Order apply, whether there'll be term limits on advisors. So that's all. I could see the advisory committee saying what's going on here.
Okay.
The advisory committees that started that.
Right, exactly.
So, I mean, nothing against the advisory committees, but that's where it started, was in ProStack.
Well, we've got a chairman of one right here, so let's hear.
Yeah, Jim Payne, Superior resident. I chair ProStack and serve on OSAC. And I just wanted to, the discussion about the conflict of interest, I'd just like to make an observation that it's, there's been some comment, and I understand it and appreciate some of the comments that is depicting this as sort of a closing down and a stifling of the committees. I can take a different view. I think that it's part of an ingredient that is part of open government. And I will commend in working on the committee and commission's work. We looked at the other towns, and I can say that Louisville has a very good document on this, and it's entitled Open Government, and it's a clear roadmap to not just town officials, but to advisory committees, and everybody participates as to what's expected and how to conduct themselves in an open government environment. So I think that's a good document to look at. I commend it to you if you haven't seen it. And I think that conflict of interest is one very clearly defined part of that, but it's an important part. And put in context, it's part of providing helpful direction toward leading towards a more open government, a more open process, more open participation in town government. So I think that's another perspective that I'd like to put out there that's a little different from the other comments. Thank you.
Jim Heidel, Superior resident, and just to disclose any conflicts of interest for people who don't know, I am the husband of Trustee Skumant, so there it's on the table. A couple of brief comments. I think that the distinction between committee members and board members and conflict of interest, when you go into your executive session or whenever you proceed with this, you need to think very carefully about different standards for those. I mean, the people in this community who volunteer, and as Mayor Muckle, I think, was one who indicated, or someone indicated that these typically, your volunteers are people who have expertise. And you, as the decision makers, can evaluate that expertise and evaluate whether they have a conflict of interest, but they don't directly financially gain. But the people who volunteer are, getting psychological, may have psychological benefits, but I don't think you should exclude them just because they're experts. In terms of the trustees and conflict of interest, I mean, there I think you have to be very careful, and I think the issue of appearance versus actual is very important. One of the things that came to my mind is if a trustee is voting on open space, how do you know if the trustee has a financial interest? What about their property? What about their property values? I mean, direct financial interest is is one thing, and I think that's a very bright standard. But you can very quickly get to a slippery slope, and I think you need to think about that when you come up with your rules as you start down that slippery slope. Where does it end? Because I'm taking you at your word. This isn't a witch hunt. You're trying to do the right thing for the town and make sure all the decisions are correct. So I just be very brief so you can get home. Just the final point, just as a matter of correction, since I was involved in the creation of E-Conservation at Sarah. Sarah does not own E-Conservation. E-Conservation is a nonprofit organization. Yes, Lisa Skumatz is on that board, but the board has a board of directors, and the board of directors has responsibilities and makes their decisions. So I think you should keep that in mind as well. Thank you very much for your time.
And I'd like to make a comment here that I happen to live, I back up to McCaslin, and I back up to the property that's called Bulljack. And I have never voted on any open space for that property, as well as Verhe, which is further south, north? West and north, further west and north of my property, and I've never voted on that as well. And so I can, make a comment here that just as much as you think there's a witch hunt happening here, I feel it coming from the audience back at me. I just wanted to make that clear, that the disclosure of the trustee living, behind Smoke and Space, and I've made that clear. I think there's been other trustees that have been up here that do live behind open space that maybe have voted on it, but that is not me.
I'm George Kuffner, 7520 West Coal Creek. I think this is a great meeting because transparency in government is what the people want. We don't elect you guys to run into all these executive sessions. I want to see transparency as a citizen in this town, in our federal government. I don't care where. In budgets or whatever, I want to see transparency. I want to be able to understand it so that I know why I voted for you and where my money's going. Thanks. Thanks for the meeting.
And George, this was the intent for this meeting from the very, very beginning. I feel like the intent has gotten hijacked, and that's not really accurate. Transparency is what this is all about. Thank you for saying that.
In honesty, I had no idea what this meeting was about tonight, except I seen it on the billboard. Special meeting tonight, and I'm thinking, this is the third. It's Thursday night. It's it's something that I probably should see as a citizen for transparency. That's. So I appreciate you guys calling. Whoever called it, I appreciate it because it opens the eyes and enlightens the rest of our community. Thanks.
My name is Karen Imburowitz, and I live at 967 East Carabel Place. I served on the town board for 8 years, and I served with Trustee Skumatz, Trustee Gregorius, Mayor Muckle, and I think Trustee Sorelli, maybe?
For a few months.
For a few months.
Just not.
Although we didn't always agree, we often did not agree, we always trusted that we were here at Town Hall spending our time and our energy to make this place a better place to live. And I think that's what you all want to do as well. But I think when you get down to picking apart people's motives for voting a certain way, that you're going into really dangerous ground. And you don't need to make more rules to follow. If the state has a law that says, they've thought about this a lot. They have a law that is written the way it is because that works. You could try to reinvent the law here, but I think you're going to find you're going to run into some problems. I had a question for Lisa. Trustee Skumatz, are you recommending that E-Conservation receive a grant from the town?
Not at all.
Okay, so let's just get that out in the open. Nor is CIRA planning to do any work for the town. Okay, so that's not happening. There's no money being expected to be exchanged between Trustee Skumatz and either of her businesses, nonprofit or for-profit business.
If I may, real quickly, Karen, I'm sorry, but you're addressing the issue that we've been told we can't discuss in the open, that we've got to do it in an executive session.
I'm not asking for attorney advice.
Well, but, I mean, if you're going to lob that over to us, we've got to have the ability to respond. And I think that if we had an open discussion about that letter, and we had an open discussion about some decisions that were made in OSAC, I think that you guys would agree that we've got a reasonable assumption that there is a conflict of interest in both OSAC and on the board.
But it can be discussed. You just can't get attorney's advice in open forum. That's all. That's all she said.
Okay.
So, and then tonight it was brought up that we should read the ethics rule of conflict of interest at the beginning of every meeting, committee and otherwise. I think if you're going to do that, you should probably read every ethics rule at the beginning of every meeting. Because why is the conflict of interest ethic rule more important than other ethic rules? I just think that there again, you're going down a slippery
Can you
slope.
give an example, Karen, on what
which
you mean?
There are lots of ethics rules, so I don't know why, the board would pick one to read at the beginning of each meeting.
The intent there, Karen, is to remind ourselves of our obligation. I agree with Trustee Gregoris when he says the intent of this meeting's been hijacked. The intent of this meeting is to educate ourselves. The code, as you evidenced here when Kendra and I were going back and forth, the code is out there and it puts forth provisions. That's the town code. The state code puts out additional provisions. It is, in my opinion, for me, and my personal goals as a trustee, to understand those rules. And so that's why a bunch of us are gathering here tonight. So we personally can understand how we must perform to be in compliance with these rules. There is, to address some of the committee members, I'm totally, of course, more allied with transparency and open government in that if I personally feel that there is some connection I have to a person or a financial interest, that now I know to disclose. Frankly, what I learned tonight is I will disclose if I am in that situation, and now I know when to disclose. But I also want my compatriots up here, and I trust basically good faith, that if they legitimately feel that I have some interest that I need to disclose that I'm not, that they will keep it on the up and up and remind me of that issue and ask me if perhaps I shouldn't be prudent and disclose. I don't think it's going to get malicious. I don't think it's going to get contentious or cantankerous or whatnot, but I think we are identifying here a common set of standards by which we all agree to conform. And there, as much as we can make this a common set, it's not open to my interpretation or Elia's interpretation or Deb's interpretation. There is a well-defined set of standards by which we all agree to conform. And if we can reach that, I think that's only good for good governance.
I would have hoped you had reached that when you read your board packet and when you were introduced to this board. Every one of you read that board packet, and you should know what those rules are. You should not have to have a meeting like this where you're talking about in vague, samples or examples of rules. It's just a waste of time, first of all. And if you needed to call a fellow trustee out on whether you thought there was a breach of her disclosure of conflict, then you could have just called her out. You didn't need to have an executive session.
Unfortunately, some people are telling us why we're here tonight. I'm here to say I'm here tonight for a broad discussion of conflict of interest so that I can be informed. This was not, the idea of a witch hunt has been put forth by the others outside the board. That is not the reason I'm here tonight, but I wanted to maybe disagree with you on one thing. When we talked about appearance of conflict of interest, the attorney's first comment was that there is nothing in the code that requires us to disclose an appearance. And then I read the code, and it says point blank, you must disclose an appearance. And it became a very important part of this discussion. So even, understanding this code isn't as simple as just reading it. I've read this code in the past several months, 6, 8 times, and I have to tell you, I'm still confused by it. So I think there is a reason to clarify it.
Oh, just one quick comment to you, Karen. I mean, you and I have sat up here together, and we've agreed and we've disagreed, and it's all been good in the end. When you were a board member, if you had multiple people, citizens of the town of Superior, that came to you and said, we believe, or it appears that a trustee has a conflict of interest, did you feel like you could answer them honestly, yes, there is a conflict, or no, there isn't? Because I'm not a legal expert. That's why I came here to get educated, actually.
I just think it's strange that you decided to do it in a public forum. I always felt like I could go to the town attorney and get advice from her and decide how to proceed from that point on. That's what makes it feel like a witch hunt, that you decided to call a special meeting and that we're talking about one trustee, and while you're not talking about it, and that it could have all been done without this big public affair.
And by the way, should have been done when you got on the board. If you're this far into your tenure and still confused, that's a really, really big problem.
No, because this issue hasn't come up, James, before. I've been here for 4 or 5 years. This is the first time I have several people come to me and say, does this appear? If it happened 5 years ago, we would have had this meeting 5 years ago. This is the first time that has happened. That's
Right,
why
and
we're doing it
James,
now.
you heard straight from the attorney, these rules are confusing. You've got to understand the local, you've got to understand how the state supersedes, how the strictest code that's out there prevails, and...
The question I have is why
Well,
are you just
you know what,
today?
I think,
I just
really,
want to
it-
say two more things. And
two more things, but I think without anybody here who can actually speak intelligently to this, i.e. the attorney, probably isn't going to be any more productive anymore, and I'd recommend wrapping it up if that's okay.
I just want to say imposing rules on our advisory committees shouldn't be a problem, since you don't, I mean, they need some rules, but I don't think they need more rules now. You don't need to listen to the advisory committee, and in fact, you don't. The
Well-
OSAC advisory committee recommended someone they would like to serve with on the committee, and you chose someone else.
There is a, if I can clarify...
This is not open
Yeah,
government.
yeah.
It feels like it is being closed
Right.
down by
Right.
people trying to impose rules
Right.
and having conversations that are not at all clear.
I'm hearing you, Karen. On the advisory committee thing, I do want to disclose one aspect of that, and I do intend to actually add that to the agenda for this advisory committee. There's a very specific incident that some of us are concerned about regarding a particular issue. I'm not even going to go into any aspect of it, that I will talk with my peers at the advisory committee, at the executive session about this. This is, and that is where the concern has percolated, that perhaps it would be beneficial to inform, just the way we're being educated, advisory committee members on when they may want to recuse themselves or when they may want to disclose a conflict. So it emanates from a very specific set of circumstances, and after the executive session, if in fact it's appropriate in a board meeting, we can disclose that set of facts. Anyway, just wanted to put that forth.
Right. Mr. Mayor, I just had, as an OSAC, since it was brought up, I just have a really quick, unfortunately, I had to find out, as you brought up something about the conflict with OSAC, and again, this is part of the reason why there's a problem, I think, conflict between the boards and the committees. No one ever asked me as a chair. I also had to find out, basically, backhand through the attorney, that there was a question specifically with me. I think that is really underhanded. I think that is really something when you talk about open government. I just want to state I've been on OSAC for many, many years before I was ever on the town board, before I ever knew anyone here who may have voted. No one voted for me on the town, that's on this town board. No one voted for me for OSAC. I've been on there for many, many years before I knew anyone here. And so, again, I really think that open government, you really need to take a look at yourself before you start.
I'd be happy to talk to you about it, because this has nothing to do with you.
Well, I'm sorry, but I've also found out that maybe you're not aware of some of the other things, but I've also found out other information, unfortunately, and it's really sad that no one calls anyone. I have a telephone number, I'm easily accessible. So if you want to get a hold of me or anyone else, I imagine in the other committees or even on the board, I think just a phone call would do.
So, as we wrap this up.